The reasons behind this are that different high courts have constantly challenged the right against self-incrimination in different cases. Secondly, the violation of the right to privacy in the present case has been established beyond a reasonable doubt. The judgment starts with describing different forms of the right to privacy, but at the end of the case, it seems more inclined towards the concept of the right against self-incrimination. In this case, judges have covered two important aspects of the Constitution: the right to privacy, Article 21, and the right against self-incrimination, Article 23. In India, this entire topic of privacy has always been undervalued. The judges in this case had to rely upon foreign judgments as a reference while deciding the case, as no such landmark judgments are available in India. Even if different high courts decide some cases, they cannot be cited as the authority. From time to time, those cases have been challenged in other high courts, and somehow contradictory judgments are available, making the situation more confusing and delusional. For example, the high courts of Karnataka and Delhi had narrowed down the understanding of narco-analysis by holding that these statements given by the accused cannot be a violation of Article 23 because these statements are not known to the accused, and he would get to know only after the administration of the test. Exceptionally, in this case, in the course of establishing the theory of natural justice, the Supreme Court has observed that the utilization of neuroscientific techniques such as brain mapping, narco-analysis, and polygraph tests on an individual recognized as an accused, witnesses, and suspects without their consent shall be considered to be an unconstitutional approach and violation of their right to privacy. Thus, Supreme Court finally cleared the situation with this decision. Although, by virtue of Section 161(1) of CRPC, the investigating officer has the full authority to examine any person orally who is supposed to be well aware of the facts and circumstances of the case, the fact which has to be noted here is that such an arrangement is here to ensure the citizens' cooperation and participation in the investigation, so police authorities cannot override the constitutional protections given to accused persons. Supreme Court, in the landmark case of Maneka Gandhi, one refer, Union of India, wherein the airport authorities confiscated the passports without giving her any reasonable notice, held that the right to privacy is an essential ingredient to constitute personal liberty under Article 21 of the Constitution, which shall, in turn, is comprised of the right of an individual to be liberated from restrictions or encroachments into his life, even though calculated measures directly or indirectly impose those restrictions or encroachments. The right to privacy, including the right to be not treated as inhuman and the right to a fair trial, is also an essential component of personal liberty. Conclusion.